Alright, Chapter 8, Contracts of Sale, Essential Matters to learn. This chapter, contract of sale of the real estate must contain all elements required in any of the contract, legal to void, mutual agreement, offer, acceptance, consideration, legal, competent parties, lawful purpose, description, adequate, identified property. Condition, statute, fraud, laws that require the contract of sale of the real estate be written and enforceable, various names, either the local custom for contract to sell real estate, the names include the contract of sale, agreement of sale, purchase of sale, agreement, offer, and acceptance, earnest money, contract. Contract to sell precedes settlement of the closing where the buyer typically provides payment with the direct exchange of the deed with the property delivered by the seller. At this time, an interval necessary become the time period for the buyer to research the title, arranging financing, perform inspection. Many states special form is required to use for sale, and licensed broker salesperson form not used. The special form requires more than a minor changes. Broker may not make the changes, but instead must have the form drafted by an attorney. A valid contract of sale will typically include interest, identity of the parties, description of real estate, principal, financing required, contingency to be resolved with other terms of sale, settlement date, signature of buyers and sellers. Avoid disputes. Legal description of the property should be included in the contract. However, the minimum description is one sufficient to locate the property. The principal party should state with the total paid and the financing to be arranged. The amount of the terms and type of loans will be sought for the contract acceptable. Contingencies include such things as inspections, property condition, including structural, mechanical, electrical, plumbing, termites, environmental. The buyers need to do something such arrange financing, sell another property. The contractor should specify who is the repairer, the payer for the repairs, what happened if the cost of repairs exceed the specified amount. Unlike the price for the merchandise retail, the department store, the price of the terms of the real estate are non-negotiable. Our negotiable negotiation process typically starts with the prospective buyer who presents an offer, often through the broker to the owner. The offer with they will withdraw any time before it's accepted. The owner may sign the offer as it presented, make no changes, and call the acceptance which creates a contract. The owner may decide not to respond to offer, in which case the offer is voided on its expiration date, either withdrawal the prospective buyer. The owner may change something in the offer, slightest change that constitute the rejection of the offer, substitution, new offer, the other party, or counter offer. The process will continue back and forth until acceptance occurs, at which point the contract exists, until the party decides to break off the negotiation, no longer pursue the contract. Due diligence of the process buyer performs of certain property conditions described with no surprise of physical, financial, legal arbitration. Legal attributed to settlement. Closing date is usually stated in the offers when the phrase of time is the essence of the deadlines are interpreted exactly. The deadline of the other requirements of contract made, mutual agreements of the party, power of attorney, POA, is usually given another person with the authority to act with the person with such authority is called the attorney. In fact, party needs to be an attorney at law. If the intent with the transfer real of the power of attorney should be in writing, it will be enforceable. Earnest money is called hand money, the deposit given by a buyer or seller or broker if one is involved to show good faith. Most situations, the seller keeps the earnest money. If the buyer defaults, however, the contingencies stated in the contract are not met, the buyer is entitled to be a full rerun of the earnest money. Liquidated damages, sometimes stated in contract, defined penalty for the failure to complete the contract specified. Specific performance legally remedies sought by the buyer to compel the seller to complete the contract and enforce court allowed because each piece of real estate is unique. Contracts for the sale of real estate remain valid on the estate of the owner who died, called the descendant, such as leases, deeds, mortgages. The listing normally terminate on the death of either party, owner, or broker. Contracts for real estate are normally assignable to transfer someone else. The signer party who assigned the contract is not relieved of the obligation until the opposing party agrees to such release. Document used to release the party to a contract substitutes another called a novation. Contract the sale of the real estate describes the right of obligation for the purchaser, seller of the real estate, a day, weeks, month, or later. Ceremony is called the closing or settlement, or the sellers will deliver the deed with the transfer of legal title to the property. The purchase will provide payment of the property described in the contract of sale. Contract of the sale of the real estate is the deal that means the provision of the parties want all and if ands but set forth in this contract. All negotiation, wheeling and dealing, give and take, such have occurred to be sold before the contract sale of gifts. And once there is a contract sale, that it's too late for any more negotiation. All of the parties' agreement must be abided. None of them may change anything in it unless all the other parties agree to change. Therefore, it is important for the parties to correct, make sure of the condition and the requirements that they were regarded to the sale purchase of the real estate contained in the sale contract. Hard contract sale of the real estate is profitable to sell property merely with the delivery and the deceit of the exchange of the payment, thus of the bypass of the contract of sale. However, the party, especially with the buyer, face out of a lot of risk. Title search must be performed to satisfy the buyer that the seller can give the ownership. The time is required for such search. Buyer must also need time to arrange financing and inspections. Most lenders would consider the real estate loans only after they study the contract of sale, ensure the rare of the transfer of the real estate completed without such contract. Furthermore, paramount importance of that all parties involved with the transaction understand the contractual obligation privileges upon completion of the contract. The purchasee who receive the equity. The law attempts to treat things as they should do, fair, and consider the purchase to have equitable term title, although the legal title remains with the seller vendor until the closing. Therefore, if there casualty, loss, or fire, for example, foreclosing the risk upon being upon the purchaser. However, concerning the equity intended to be fair, but the risk lost before closing should not pass automatically to the purchaser. In all instances, there are situations in which the seller would be reasonable. The courts would help hold them to be so. To avoid potential problems concerning risk of loss, contract of sale should specify the burden of loss prior to closing with a party obligated to complete transaction, receive receipts, and insurance. Statute of frauds require the contract of the sale of the real estate to be writing and enforceable. The parole evidence rule prevents oral testimony from being introduced when it conflicts with better written evidence. Consequently, there should be an exercise preparation contract of sale. Contract of sale should contain a contingency clause or contingency if the parties want. This is what-if provisions that often allow the buyer and seller to cancel the deal without penalty of selling something does or does not happen if in part. For example, the seller may have her home in the market because their employer is transferring her, but he wants to be able to cancel the deal if the transfer falls through. A buyer may need to sell his own home in order to be able to buy the seller's property, so he wants to be able to cancel the deal if he can make the sale of his own property without a reasonable time. A greater many home buying contracts or sale or contingent upon financing means that the buyer can cancel the deed if he is unable to getting a suitable mortgage loan. Many pre-printed contracts of sale have common contingency already written in them. The buyer can cancel the deal even if the seller cannot provide the clear title. If the property is severely damaged before closing, if termite infestation is found, the seller can cancel the deal if the buyer does not get financing approval with a certain time. Many states require the seller to provide a buyer with a disclosure of certain conditions that affects on the property. If there are any of the seller that provide with the buyer with a statement of such conditions, that's usually the state mandates a certain form upon which the disclosure is made. It's possible the disclosure must be made available to the prospective buyer before the offer is made, and so usually with the first contract between the prospect and the seller or listing of the broker occurs. If the broker transaction says the disclosure normally provided with the broker when the property is listed, the broker will then provide a copy of the potential buyers examining the property. Transaction is not brokered. It is the seller's responsibility to provide a disclosure of the potential buyers. A deposit or earnest money is not necessarily a legal requirement of the contract of sale, but the parties' promise to perform in the future are usually sufficient to require consideration, but very common. The buyer does not put down the cash deposit at the time of the contract of sale is agreed upon. Function earnest money is served the evidence of the good faith intentions of the performer under the contract. Some state, however, the future about their term of the earnest money specifying that it has certain meaning. For example, in some states, if the deposit is called earnest money, the buyer may abandon the contract, no penalty except forfeiture of the deposit, and the seller can abandon the contract by returning the buyer's deposit and usually an additional sum such as amount equal to the buyer's earnest money. In these states, therefore, in order to require the buyer and seller to go through with the contract, any deposit must be specified to be something such as a prepayment or the purchase of the price. This is not what the state defines earnest money. Check the law in your state. Requirements of valid contract of sale. To assist learning of the contracts of sale, get a copy of one of the local real estate brokerage office or buy a generic one usually available online. You might also be able to download one from the State Real Estate Commission website. Note that in some states the contracts may be called something different from the contract of sale, such as agreement of sale. In Texas it is earnest money contract. Don't worry about the name though. Whatever it's called, wherever you live, there's generically contract of sale. And like any contracts of sale must conform to general requirements described in Chapter 6. within the contracts of sale. There are 6 essential that also must be observed: the interest, identities of the parties, description sufficient, locating of the real estate, 3, the price and how it's to be paid, 4, contingency, the other terms of the sale, 5, settlement and date, and 6, signature of the party. 1, interest identified with the parties. Who are the buyers? Who are the sellers? There are parties of the contract. The name of the sellers should be, and they are on the record deed of the property. The name of the buyers should be as they will be on the new deed. 2, legal description of real estate. Real estate with the method of describing real estate presented in Chapter 7. Simple description, lot, block, number description, uncomplicated, rectangular, survey description should be written into the contract. Whatever is written into the should take special care to make sure the description is accurate. If the description is complicated, chances of error are high, especially with the meets and bounds description of the bound numbers of the directions or so on. With the complicated the description often won't be written in contract, but will be incorporated by reference. The location of the existing accurate version is described instead of the most commonly referred document will be on one of the ready of the public records. Obvious one existing record deed to the seller. If there's no incorporated the description by reference that you refer to whatever the document the deed refers to. Because the public record is open to anyone, it is easy to find referred document and get the description from it. An example of reference description could be the all the land described in the X from X to Y, dated in June 7th, 1941, page 133, book 122 of the Coppermine County, Montana public record. They tell anyone with the reads of the contract exactly what they find in the description. The description reference can be used only with the real estate currently being transferred exactly as the same as described in the reference description. If any changes have made with the boundary of the land, the new description must be written. Note: land descriptions do not contain information for improvements of the land, house, or drive, etc. That's okay. Remember, real estate is land, all permanent attachments to it. If you require described land, you are getting whatever is on it. 3, the price and how it's paid. Exact price must be described. Usually a buyer does not have cash to pay for the property. Make sure that must secure the mortgage loan to be able to complete the purchase of the contract. Should be described the actual cash amount that must be provided with the buyer, the amount of the borrowed money that will be provided if the seller will accept the IOU for all parts of the purchase price and the purchase money mortgage. That what we'll call seller's financing that should be included. It would be wiser for the buyer to insist including the desired term of the mortgage loan they need, the maximum interest rate that they will pay, the term 15 years, 30 years, etc. Any other loan terms that considered important, as well as stipulation that they can find the desired loan within the reasonable time, will have the right to cancel the purchase at no penalty. Alright, 4, contingency, other terms of sale. There are what if the other specific requirements parties agree to will describe one contingency above. What if the buyer can't get the mortgage loan they want, where they can't back out of the deal without losing anything? Many of these are written in standard contract form. The seller must provide good and marketable title. The buyer must apply for the loan within blank days. What if the buyer wants to move before settlement date, or the seller wants to stay on for a while after settlement date? Should the rent be paid, and how much? Common requirements include appraisal, inspection of the property, condition, electrical, mechanical, plumbing, and the like, structural condition, absence of wood, destroying insects. 5, settlement date. In some places it's called the closing date. Must be a contract sale with a deadline, with which the contract requirements should be complete with a deadline, which the buyer must pay for the property. Seller must provide a deed without the settlement date. There isn't a requirement for the contract to be completed. Either party could dawdle all they want. Most contracts include the phrase "time is of the essence." This means the reference to deadlines are interpreted exactly. If it turns out that the date of the contract is optimistic, the party does not have to complete everything they have to do. Settlement date can always be amended later when a mutual agreement. Part 6, signatures of parties. As within the contract, all parties must sign it. It is the legal way of showing that they all agree. A signature of the contracts do not have to be notarized. If they look up at the contract, you may sanction of the commission to the books where it is to be paid and describe. Some generic forms include Part 2 of this section. Actually separate contract between seller and broker. It's really not necessary because the listing contracts already obligates the seller to pay the broker. Most of the brokerage firms include in their contract set of sale forms anyways. Pre-printed contracts of sales almost always use sales of homes. Suppose there is something already written in the pre-printed contract. The parties do not want the part to apply them. They simply cross out the part, and the parties initially sign near the party of the contract acknowledge that they agree to the alteration. In some states, the formula propagated real estate commission must be used licensed, especially residential transaction. If any more than a minor change to a form is used, the paperwork must be provided by an attorney. Otherwise, the broker might be accused of practicing law without a license. The contract sale is not yet signed and referred to as executory. After it's signed, all the necessary parties is called executed. Negotiation, offer, and counteroffer acceptance. Contract of sale of any kind just don't pop out of the air. They're ready to go. They are resolved in negotiation. Negotiation contract sale of the real estate usually begins with an offer from the interested potential buyer, the person making the offer, or the person receiving the offeree. Buyer probably knows that the seller wants price terms, etc., but very often the buyer won't agree or to everything, so the offer will be somewhat different from the seller's desire. Seller will consider the buyer's offer, can either accept it or turn it down and make a counteroffer back to the buyer. Now, if the buyer turns, she may accept the seller offer, turn it down, and make another back to the seller. This can go on for several cycles. Eventually, either party will agree on the final deal, and the contract will be made, and they may decide hopeless to stop negotiating and go their own ways. A key element of the negotiation process: no one involved obligated to anyone until the contract exists. No one is required to negotiate. No one is required to keep the negotiation unless once process has begun. Anyone involved may terminate the process simply by refusing to go with it. Lay down some of the most simple rights for the negotiation process. Once an offer is accepted, it isn't an offer anymore. It becomes a contract. The offer of the contract is if the negotiation proceeds and because the parties have finally agreement. There is no more discuss. The party latter decided that he wants some of the more conditions to the light. Contract already exists. He must abide. Of course, he can always approach the other parties to amend the existing contract. The other parties have the negotiation and reopen the negotiation. During the negotiation, one of the offer can exist to give it a moment in time. If A makes an offer to buy B's real estate, an offer exists up to B to decide what to do. 1. She can accept A's offer to thus create a contract. 2. She can reject A's offer, in which no case offer exists anymore. 3. She makes a counteroffer back to A, in which A offer does not exist anymore. Now there's another offer on the table to B to A. Making the counter therefore means two things are being done simultaneously. The offer that was on the table and is rejected, and new offers in the other way. There's one other thing that is going on. An offer to withdraw at any time, as long as it has been not accepted. While B is pondering A can at any time notify B of the offer is withdrawn. It happens to the end of the offer no longer exists. But if before the B notifies A that she accepts the offer does not exist because it has become a contract. You can't withdraw a contract. An offer rejected does not exist anymore, can't be resurrected later, and consider the following conservation. Jane makes I'll give you $150,000 for your house. Mike says, no, I need to at least $175,000. Jane says, forget it, it's too much. And Mike says, okay, then I'll take it to $150,000. If there's no contract, Jane, to buy Mike's house for $100,000, no, let's take it step by step. First, Jane made an offer to buy Mike's house at $150,000. Mike counted off the house at to Jane for $175,000. But in doing this, rejected Jane's offer of $150,000. He then replaced his offer to him with his offer at $175,000. Jane then rejected Mike's offers to her, but she did not make any other offer back to him. At that point, there was no offer on the table at all. When Mike said he'd take $150,000, no contract came into being because there wasn't an offer from Jane anymore for him to accept. He has already rejected Jane's original offer and does not exist anymore. His statement, okay, I'll take $150,000, actually create the new offer from him to Jane to sell her house for $150,000. She does not have to accept it. If she does, Mike and Jane will have a contract. If she says something like, I've changed my mind, I don't want to buy your house, then she is in turn rejected Mike's new offer, and there's no offer on the table. This is a very important aspect of the law offer of the acceptance. Until contract exists, no one has an obligation to anyone else. It's if you look at a certain pre-printed contract of sale, you may see language of order. If the offer remains open and you blank, you're supposed to put a date and time on the date in the blank space. What does this mean? Most of whatever made offer wait until the deadline is set to see other parties accept the offer. If the other party guaranteed the length of time ponder offer no is because there's an offer. No one is obligated to anything. The offer can withdraw the offer any time until the offer acceptance. The only way the language is interpreted is mean. The deadline arrives and the offeree has responded to the offer will automatically withdraw. It will be withdrawn at the time and in effect with the provision putting a limited life on an offer and nothing more. Many real estate agents are apparently unaware of the part of the law. Frequently, the situation with someone wanted with the withdrawal of the offer may they go better in one. In the meantime, the licensee told them you can't do that. You're agreed to leaving other open until the time the wrong could expose the licensees to a lawsuit. If the owners accepted the offer, it does not become a contract until the offer for the offer's agent has been notified that the acceptance laws say that you cannot be held with a contract if you don't know that it exists. Because the notifying an agent is the same as notifying the agent principal. The buyer tells the listing agent that he or she accepts the counter offer for sale of the contract exists at the point, or if the buyer agent is notified after the seller accepts the offer from the buyer that there is a contract. Either case, the professional license will immediately call it for his or her principal to notify them of acceptance. Notification does not have to be written and can be oral or such a phone. Finally, in common practice, especially broker transaction and offers between potential buyer and seller is to be made with a contract on sale form. The typical buyer wants to make an offer on the home. The buyer agent is involved to fill out the contract and sales form with all the terms of the buyer wants written into it. The buyer signs it. It's submitted to the seller. The seller accepts the offer. He signs it. Contracts exist. Once buyer is notified, seller presumes happy because he got an offer that he is willing to accept. The buyer is happy because the seller agreed to all the terms, condition, prices, and so on that she wanted. Most of the time, though, the offeror does not agree with all the terms of due to the offeror. Counter offers made common practice cross out the parts of the offeree doesn't like, and the written desired charge of the marginal form is to add anything else desired in the same way. The offeree initials and signs all of the changes signed of the document submits to the offerer. Because the counter offer rejects the original offer and the offeree now have changed places. Of course, new offeree may not like all the changes, might cross out more stuff and write in more stuff. The initial sign those changes and send it back to the new offerer. This process can go back and forth again and again. Cumulative marginal changes and cross outs can result in a contract that from form as being unreadable mess. So that when it gets into that point, it's certain good practice to prepare a fresh form with terms and conditions written into the reflecting of the current state of the negotiations. Are parts of real estate contracts of sale. Contracts of sale real estate normally contain a certain part of the parts of their purpose. Parties states the name of the seller and vendor and buyer. Property description provides legal adequate description of subject property. Fixture includes sales price, state the amount of the being paid at closing and the cash from the preceding finance. Assignment describes whether the part can assign the contract to another party. Assignment does not relieve the assigner of the obligation to perform. Financing condition. Purchaser stipulates the accept of the condition. Financing including the type of loan, the loan to value ratio, interest rate, monthly payments. Earnest money notes the amount of the good faith deposit presented to the seller or his agent, also called hand money or escrow money. Type of the deed describe the type of the deed given in the closing. See Chapter 9. This is the title evidence. Describe the title evidence considerable satisfactory. Assurance that the seller can give the title. Title approve the discover the right of the purchase seller in the event of the purchaser objects to the flaw in the title. Property and condition states whether the changes are, if any, are required to be made with the property inspection. Maximum cost of repairs parent party must pay. Prorations called prorations prepared unpaid taxes and insurance, rents, etc. Between buyer and seller. See Chapter 18. Loss effect. This is responsibility casualty losses until closing. Possessions established the day of possession. Closing established the date of closing. Broker knows existing real estate broker file. Fee specified by the common rate, commission rate, identified by the principal who will pay the commission. Default describe the obligation parties event. One fails to perform. Contingency describe what if provisions of the contract for the condition any of the parties may cancel the contract without penalty. Miscellaneous provisions state whether the other provision of the buyer or seller agree upon. Signatures, principal, broker, escrow, agent. A real estate owner may give another person power of attorney with the sale of the real estate. Available to the sale of the real estate, power of attorney must be written. Power of attorney expresses upon the death of the principal. However, the property was under contract to sale before the principal death. The contract remains valid. Contract to sale, lease, mortgage of the real estate remain binding on the heirs after the person's death, listing with his owner's death. And that was Chapter 8.